Now, these issues were never discussed in Nabam. That's why Mahankar says that there can be no, there is no specific. That's why Maharaj is allowed to participate in the proceedings of the House. He is allowed to speak, he is allowed to vote.
Yes, Mr.
Then it becomes under consideration on the appointed day. That's why I was telling your Lordship my experience in Parliament. What happens is, Maharaj, supposing there's a bill, forget about this removal. There's a bill, Maharaj. What do? We stand up and I say, do I have the leave of the House to introduce the bill? The House leave, the House is asked for. The leave is granted. I introduce the bill. But it's only introduction. Then, Maharaj, the matter goes to the Business Advisory Committee. In the Business Advisory Committee, after discussion with everybody as to when you should bring the bill up, Maharaj, then a date is fixed. Then on that particular day, Maharaj, some other matter may be going on, Maharaj, it doesn't come up, it goes on to the next day. Then, Maharaj, when it comes up on the next day, we rise in our chair and we say that I propose to move the bill for the consideration of the House. That's when it's considered. The same procedure applies. So this whole argument at the time of the problem with Nabam is, it says the moment the notice is given, you can't function. That's what Nabam decides for us. Therefore, these rules are all ultra-virus according to Nabam, because you can't preside. So these are serious issues. And there are live issues, these are not dead issues. Especially in the context of that letter, notice on 22nd, dated 21st. The idea was not to allow the speaker to function. The whole purpose was that. Now your Lordships put to me, but then it's a free, and rightly so, that the speaker has no impediments in his way to decide the matter. But that's what Holohan says. What does 110 of Holohan say? There can be no legitimate action before he decides. That's 5 judges of this court. Therefore, the 27th order could not have been passed. Your Lordship put it to me that no, he only adjourned it. In the interim, I adjourn it. I give them time to file a reply. What does in the interim mean? You extend the time, I can't decide. What else is it except stay? What else is it except violation of para 110 of Nabam Rebia? What else is it but it's a quitimate order? Can you put it in any other framework? No, I'm sorry. So Nabam, Holohan says you can't interfere. If you can't interfere, then the speaker has to decide. And the whole problem arose because of the 27th order. That's a live issue. That's not a dead issue. That's not academic. Because it was on 2 grounds. Nabam Rebia and 2 days notice. So if that was that, everything will go. Because then what it catapulted into a situation where an elected government is toppled. Because of the disqualification of the deputy speaker not being able to decide. So my respectful submission to your Lordships is that 179 for removal operates in an entirely different field. Now, I must also disclose to your Lordships that the Maharashtra rules do not have this what the Lok Sabha rules have.
So what do we, the flip side, situation where it's not really a case of an anti-defection, it's a case where there's perhaps a realignment, even a starker case than this, where there is actually realignment is going on. And the Chief Minister is in an awful minority, then knowing the writing on the wall, the Speaker would want to declare all the others who are on the other side as violative of
he can't unless there is a petition before him.
That's another.
Yeah.
Petition part of it is what you are saying, this application, this notice is actually not equivalent to a petition. We are on the interpretation. We are on the question of should the speaker restrain or postpone it till some point of time. We are only on that question. In a situation like this, in order to preempt a situation, speaker takes up the matter and immediately disqualifies them.
Let me answer that. Very important question. Let me answer that. Let's now bifurcate these two. One, you can't have a notice before a petition for disqualification. That's one part. You can only have a notice after the petition for disqualification.
Okay, that point is taken. Well, go to the next
notice.
What's the next
now, supposing there's a notice after the petition of disqualification. In that event, everything would have happened already.
Suppose there is a notice.
The facts would have happened already, because the notice will have to be based on
situation where a notice is there. Take a situation. Assuming for a minute that this 20, instead of 21st, it's a 20th notice. Then what will happen?
Not 20th, 21st.
No, there is a notice on 10th schedule.
Yes.
Already given by one of the minority members. Then what will happen?
I'll tell you, Lordships, what.
Then the speaker proceeds further to disqualify all of them.
Why not? Because that's the law. That's why I said under the 10th schedule, there is no minority-majority issue. There is only a merger issue.
So therefore,
There is no defense under the 10th
in
schedule.
about 2 days' time, he proceeds to consider the 10th schedule and immediately he passes.
But Manoj, if out of 55 or 58, 40 are on the other side, it's covered by the 10th schedule. Because there is no defense. Manoj, as your Lordship knows, under the 10th schedule, you are given only defenses. If there's a petition for disqualification, there is only a defense available. It was available, Manoj, under paragraph 3, 1/3 of the members of the legislative party, Manoj, decide to join the other. That was a defense available. We are 1/3, right? Now, that also has gone. So there is no defense of saying, I am in majority. Your Lordship is now taking a hard fact situation that the Chief Minister has lost confidence. Actually, he's only 50 people are, out of 50, 40 are on the other side. I assume that against myself.
Right.
Right? Now, they are still subject to disqualification. So what? That's why, as I said, these majorities can't be decided in the legislature. What they'll have to do is go to the party, take over the party, throw him out, and come to the house.
So there before disqualification, all that time is not there. By the time they go to the party, to the election commission.
That is why that is precisely my argument.
Therefore, Mr. Sibal, your argument, I mean, stretched to its logical conclusion would mean this, that even if a chief minister of a party completely loses the confidence of his own party in the house,
Yes.
whether he has a confidence or not cannot be tested on the floor of the house.
You cannot be.
Which means that, according to you, therefore, that a chief minister and a willing ally in a speaker.
The speaker will have to be with them. At least 2 people will have to be.
People have to be. There are 2 of them. You can support because we are not dealing with a defection.
No, I understand.
Where you lose your own party,
But
but then you continue because you have lost your own party.
I tell your Lordships, then what will happen? It's very simple, Manoj, then what will happen? Then what will happen is that under the scheduled Manoj, the speaker will be removed. Without anything, without any other thing, Manoj. The speaker a motion will be passed or whatever, the speaker may be removed and another speaker may be installed. But that's another issue. That situation has not arisen. At the moment, we are on what? From what date does the disqualification of the speaker commence?
It's an important question, Uddhav.
That's all. Now, let me now read something with the Constitution itself.
Yes.
For a minute.
I think you've now made your submissions on the reference or the lack of reference. Maybe.
I'm sorry.
The same thing, whether the reference needs.
Right, now just one other. Just one other thing. There's a judgment of the UP Allahabad High Court, 1964 judgment which deals with this issue, luckily.
64.
And I tell your Lordship what the judgment says. Then I'll give your Lordship judgment.
Yeah.
But there the question arose that a chairman of the Legislative Council was sought to be removed. Now, at the time when the notice was given, he was there presiding. At the time when a motion was moved, he was still presiding. At the time when the leave was sought to be granted, he was presiding. A writ petition was filed that you could not have presided at the time when leave was granted to move the motion. Right? Leave was refused. So, the question then arose and the court said, look, under the Constitution and the rules of the Assembly, he is not required to vacate his chair when leave is sought. Because the resolution only comes up for consideration when a particular day is fixed for its consideration. Precisely what we've been arguing before, Your Lordship. That's the judgment. Now just see, just the facts. The petition under Article 226 has been filed by Dr. So-and-so, who is a member of the Assembly. The 3 opposite parties in the petitions are so-and-so. On 11th February, Faridi and 8 other members of the council gave notice of resolution. Following resolution, Raghunath Vinayak, Dhulekar, being unfit for the office of the chairman of the council, should be removed from the office under 143 of the rules of procedure and conduct of business of the council. Under this rule, a resolution for the removal of the chairman can be moved only if the leave of the house is given for the purpose of 20 members of the house, rising in support of the same, when so required by the chairman to do. The question relating to leave was included as item number 3 in the agenda. On 2nd March, Raghunath Vinayak, Dhulekar, the chairman of the council was occupying the chair. After the first two items of the agenda were gone through, he put the question relating to leave for the aforesaid resolution to the House and asked such of the members as were in favour of leave being granted rising to their seats. And on only 18 members rising, he announced that the leave had been refused. Dr. Faridi and others protested against Daligas himself occupying the chair when this matter was put to the House and later walked out. But we are not concerned in this petition with what happened after the chairman had announced the decision of the House. Dr. Faridi has prayed in his petition for a writ directing or order in the nature of mandamus against the opposite parties to the effect that the proceedings relating to item 3 in the agenda of 2nd of March be treated as ultra-virus, the Constitution, and not effected, and further ordering the chairman to proceed according to the provisions of Article 183, 185 of the Constitution. 183 is parameter to 179. Without applying Rule 143 aforesaid, on the ground that it was ultra-virus and illegal. So then this matter is discussed. Para 47.
Page 72.
Page 72. My lords have for
Yes.
the words used in clause 1 of 185 are while any resolution for the removal of the chairman from his house, when his office is under consideration, and the plain meaning of these words, of course, is that the chairman is required to vacate the chair only when the resolution for his removal from his office is itself under consideration. As has been pointed out earlier, Rule 143 of the Rules of Procedure and Conduct of Business requires that before such a resolution may come up for consideration before the House, leave of the House must be obtained, and it is to be granted by at least 20 members rising in their places in its favour. The rule is within the rule-making authority of the Legislative Assembly under 208 of the Constitution, and the Council having itself provided under this rule that leave of the House must be obtained as a condition precedent to the resolution being moved or for consideration, it cannot be said that the resolution itself was before the House when only leave for moving the resolution was being asked for. Next is, some arguments were advanced as to the meaning of the word consideration used in clause 1 of 125 according to Webster's such act of considering, careful thought, attention, etc. in the dictionary. Rather than just leave a few lines, it is however not the meaning of the word consideration which is important. When there is some matter before the House, there is bound to be something before it for consideration. If the resolution itself had been moved, that resolution would be before the House for consideration.